Okay.
Willie Cater. I'm so sorry.
On Wednesday, I received an email, or the court did, with the list of repairs.
How long you say?
Right from the start, this case is already layered with tension because what looks like a simple landlord-tenant dispute is actually about two competing narratives. On one side, you have a tenant raising repair issues, water leaks, drainage problems, potential habitability concerns. On the other side, you've got the landlord framing this as routine maintenance, almost minimizing the severity, and that contrast matters. Because in eviction cases, repairs aren't just side complaints, they can directly impact whether rent is owed, reduced, or even withheld legally. Now watch closely. The judge isn't reacting emotionally here. He's gathering structure. Who knew what? When did they know it? And what actions were taken? That timeline becomes everything. And already you can sense friction building, because one side is saying, we fixed it, while the other is saying, you never fixed the real problem. That gap? That's where this case is going to explode.
Mr. Cater, hold on. Mr. Ruark, did you receive those?
I received it this morning, Your Honor. Actually, yesterday it was sent to me. I didn't see it until this morning. Most of them are routine repairs. We got a guy over there a week or so ago to address the repair issues and made many repairs. I would remind the court that for the last 2.5 years, this was not even an issue until into this eviction case before the first hearing.
Hi, Michael. I'm sorry about that in the court.
Okay.
I have a suggested resolution, Your Honor.
Go ahead.
Mr. Cater currently owes 6 months rent. That's $12,600. I would suggest for possession purposes only that we cut the rent to retain possession to $8,000. That would give him $4,000 to address some of these routine repair issues. But we had a guy in there that said the air conditioning system, the heating system is just fine, and so on and so forth. But that seems more than fair.
Mr. Cater?
Your Honor, I really don't want to get what Mr. Rourke is really talking about, because the AC and the heat repair is just fine. The issues that I'm discussing is the water that's coming out the drainage and the water that's always leaking in the walls, Your Honor. And that has been one of the main issues.
All right. Mr. Cater?
Yes, sir.
If you don't get what he's talking about, here's what he's talking about.
Okay.
They have you owing $12,600.
Yes, sir.
They're willing to cut 1/3 off of your rent and enter a judgment for that and give you a 1/3 abatement. I'm sure not admitting any liability, but they're willing to do that in terms of settlement.
This is a critical moment where the judge steps in to translate legal language into plain reality, and that's not just helpful, it's strategic. The tenant clearly didn't fully grasp the landlord's proposal, so the judge reframes it. You owe $12,600, but they're offering to cut it down to $8,000 to settle. That's a 1/3 reduction, legally known as an abatement. Now here's the key detail. This is not an admission of fault from the landlord. It's a negotiation tactic. They're trying to resolve the case quickly without going through trial. But the pressure point is the timeline 10 days to pay $8,000. That's aggressive. That's tight. And for many tenants, that's nearly impossible. So the question becomes, is this a fair compromise, or is it structured in a way that practically guarantees failure? Because settlements like this often look generous on paper, but in execution, they can be just as punishing.
Correct, Your Honor.
Mr. Cater?
And if I do enter into this judgment, how long will I have to pay this $8,000?
We're asking 10 days, Your Honor, the statutory amount.
No, I'm not going to enter in.
Okay, here's what we're going to do then. Nope. Here's what we're going to do. 10? At what time? 9 a.m. I'm going to set this for non-jury trial. October 10th, 2023. What time? 9 a.m. At 9 a.m. That will be in person. Got to come down to the court.
Yes,
And then
sir. Oh, I can't hear now.
Your Honor, may I point out one other thing?
I can't hear. I couldn't hear nothing you just said at the end, Your Honor. My
Okay,
speaker-
then let me just tell you.
Yes,
Can
sir.
you hear me now, Mr. Cater?
Yes, sir.
I just set this for non-jury trial, October 10th, 2023 at 9 a.m. in person
Yes,
at
sir.
the courthouse.
Yes, sir.
Yes, Mr. Rourke.
One other thing, I checked with the court yesterday. The court had ordered Mr. Cater to pay, I believe, 1 month's rent into escrow. As of yesterday, that payment had not been made.
It wasn't 1
That is
month.
correct.
It wasn't.
That is correct. That's why.
Yes, sir.
That's why I'm setting the immediate trial.
Right here, the entire tone of the case shifts, and it's not about repairs anymore. It's about compliance. The court had already issued an order: pay 1 month's rent into escrow. That's not optional. That's a direct court directive. And when that payment isn't made, it signals something much bigger than just financial strain. It signals non-compliance with judicial authority, and judges take that seriously. Because once a party starts ignoring court-ordered obligations, the court loses confidence in their willingness to follow any ruling. That's why you immediately hear the judge respond by setting an expedited trial. This isn't punishment, it's acceleration. The judge is essentially saying, if we can't rely on interim compliance, then we're going straight to resolution. And this is where cases tighten. Because now, instead of negotiation space, everything moves toward a decisive outcome.
Okay. I understand that. I saw that when I opened the file this morning.
Thank you, Your Honor.
All right. Thank you. We'll see you guys on the 10th.
Thank you, Your
All
Honor.
right. Thank you, Your Honor.
Our interrogatories and document requests to Mr. Johnson. So we'll just be waiting to hear back from him on those.
When did you send those to?
We sent it to his email address, and we also sent it via mail.
But when did you do that?
We sent that today.
Oh, you just sent them today.
Mhm.
Okay.
And then we also plan on filing a motion shortly for lack of personal jurisdiction.
Leave it to these law students. Well, okay, what do you mean lack of personal jurisdiction?
Yes, we believe that we have a personal jurisdictional issue in today's case because the plaintiff asserts that he personally served a notice to quit to Ms. Walker on June 20th, 2023. But Ms. Walker has made it clear that other than like appearances in the court, she's not seen the plaintiff since January 25th of 2023. And if this is true, then it should establish that there's a lack of service and then a lack of personal jurisdiction.
Don't want to make a legal argument with you, but is it really personal jurisdiction?
It's supposed to be lack of service.
Yeah, I know, but you're saying there was no notice to quit. Is that really lack of personal jurisdiction?
Just lack of jurisdiction in general.
In general.
Right.
This exchange might sound casual, even slightly humorous, but legally, it's extremely important. The defense is attempting to argue lack of personal jurisdiction, but the judge quickly redirects the issue toward what it actually is: lack of service. And those are not the same thing. Personal jurisdiction is about the court's authority over a person. Service, on the other hand, is about whether proper legal notice was delivered. If service fails, the entire case can collapse not because the claim is invalid, but because the court was never properly activated. And you can see the judge almost coaching through the distinction, correcting terminology while still allowing the argument to stand. This is a subtle but powerful moment. It shows how precision in legal language directly affects outcomes. One wrong label, and the argument weakens. One correct framing, and suddenly the entire case is at risk.
It's like a jurisdiction.
Nice save. It was like he was in the classroom, and all of a sudden,
Mhm.
It's probably going to be lack of subject matter jurisdiction because he hasn't invoked the jurisdiction of the court. But that's okay. You'll figure it out. All right. How long will it take you to get that motion in? Maybe we can solve it right now. Mr. Johnson,
Yes.
it says that on June 20th, 2023, that you personally served on Miss Walker a notice to quit. Did you hand a notice to quit to her?
Yes.
You did?
The sheriffs gave it to her.
No. You signed, I'm not talking about the lawsuit itself. I'm talking about the notice to quit for non-payment of rent.
Yes.
You handed it to her?
No, I didn't hand it to her. It was mailed to her.
Well, hold on. Because we're going to have a problem here, Mr. Johnson. Because the proof of service on the notice to quit or demand for possession says that you delivered this to her personally.
I put it on the door at the house.
Okay, well, there's a problem also. Because now you told me that you handed it to her, but then you said, no, you mailed it. And now you're telling me you put it on the door.
This is where the case starts to unravel, and it's happening in real time. The judge is identifying inconsistencies in the plaintiff's statements, and they're not minor, they're fundamental. First, he says he handed the notice. Then he says he mailed it. Now he's saying he taped it to the door. Those are three completely different methods of service, and only one of them, personal delivery, matches what was officially documented. That contradiction is dangerous. Because in court, consistency equals credibility. And once credibility starts breaking, everything else becomes questionable. This isn't just about confusion, it's about whether the plaintiff misrepresented facts in a signed legal document, and the judge is locking in on that. You can feel the pressure rising here, because once a judge starts dissecting your statements like this, it's no longer a routine hearing, it's a credibility examination.
All the stuff, because I knock on the door, she doesn't answer, and the people at the court told me to just put it on the tape it onto the door.
Oh, no,
So
don't blame the court. They didn't tell you that. Mr. Johnson,
Yes.
I need you in the camera.
I'm right here.
Raise your right hand.
Yeah.
You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
The demand for possession in this case, did you serve that on Miss Walker?
I put it on the door because she would not answer the door.
You put it on the door?
I taped
Meaning
it on the
you
door.
taped it to the door?
Yes, sir.
Pardon? Mr. Johnson. Mr. Johnson? Really? Mr. Johnson,
I'm here.
you put it on the door.
Yes.
You taped it to the door?
Yes, sir.
So why does your proof of service indicate that you delivered it to her personally to the person in possession?
I didn't say that. I didn't. Who said that?
I'm looking right at it, Mr. Johnson. The box is checked. That you served a demand for possession personally to the person in possession.
Well, I must have checked the wrong box then, Your Honor.
That single line, "I must have checked the wrong box," might sound harmless, but legally, it's devastating. Because that box isn't just a checkbox, it's a sworn representation to the court. When you sign a proof of service, you're certifying that what you wrote is accurate. And here, the plaintiff is admitting that the form does not match reality. That creates two problems instantly. First, it undermines the reliability of the document itself. Second, it raises the question, was this an honest mistake or negligence in a legal process? And judges don't take that lightly, especially when jurisdiction depends on it. Because if the service wasn't done properly, then the court technically never had the authority to hear the case in the first place. This is the turning point where procedural error starts outweighing the entire substance of the dispute.
Well, gee, Mr. Johnson, because there is not a box, Mr. Johnson.
But she never answered
There
the
is
door.
not a box for taping it to the door.
If she doesn't answer the door, I had to tape it to the door.
Okay, we've gotten past that. You told me you taped it to the door because she won't answer the door. Okay, I don't know if that's true or not, but let's assume it's true. What I'm telling you is that you represented to the court that you personally delivered it to her and signed it. And that's not true. That's point number one. Point number two is taping to the door the demand for possession is not a proper form of service of the demand for possession. You understand that, Mr. Johnson?
Yes, but the officer tried to give it to her too, and she wouldn't answer the door.
What officer? In this process for the demand for possession, there's not an officer involved. You signed a document that you submitted to the court indicating that you served on Ms. Walker this demand for possession on June 20th, 2023 by delivering it personally to the person in possession. That's what you signed. That's what you submitted to the court. And based upon what you just told me, that's false. And then even what you tell me is not proper service for the demand for possession. So here's the problem. And now, counsel, this is where you were going to go when you were going to type it on the paper, but just stay with me. In order to invoke the jurisdiction of this court for this type of proceeding, I have to have a proper notice. That proper notice must be served upon the person. By your testimony, I don't have a proper notice. Therefore, the subject matter jurisdiction of this court, since I'm a statutory court, has not been invoked. This case is dismissed. The court lacks subject matter jurisdiction. Thank you.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Young man, you understand what I just did?
Yes.
Okay, all right.
Thank you, Your Honor.
You're welcome.
And just like that, the entire case collapses. The judge makes it clear, without proper service, the court's subject matter jurisdiction was never invoked. That means legally, this case never even had the right to exist in this courtroom. It doesn't matter what the rent amount was. It doesn't matter who was right about repairs. None of that gets evaluated because the foundational requirement, proper notice, was never satisfied. This is a textbook example of how procedural law can override substantive claims. One mistake in service, one incorrect representation, and the entire case is dismissed. Judge Simpson delivers a clean, decisive ruling, no hesitation, no ambiguity. Case dismissed due to lack of subject matter jurisdiction. The key takeaway? In law, process is power. If you don't follow it correctly, you don't even get heard. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.